Welcome to the 41st video in our weekly legal update series. In this video, we will be discussing important news items from 30th August to 4th September 2021. In first important news, the Supreme Court has held that oral directions by High Courts to restrain arrest under Section 482 of CrPC is irregular. In the case of Salim Bhai Hamid Bhai Menon versus Nitesh Kumar Magan Bhai Patel, court has noted that oral observations in court are in the course of a judicial discourse. Issuing oral directions restraining arrest does not form part of the judicial record and must be eschewed. The court has further noted that the administration of criminal justice is not a private matter between the complainant and the accused, but implicates wider interest of the state in preserving law and order, as well as societal interest in the sanctity of the criminal justice administration. In second important news, the Supreme Court has held that equal pay for equal work cannot apply merely on the basis of designation. In the case of Union of India versus Manoj Kumar, court has held that the principle of equal pay for equal work does not apply merely on the basis of designation, and the court has relied on Union of India versus Tarit Ranjan Das 2003 case for this particular finding. In third important news, the Supreme Court has held that verification of caste certificate on repeated inquiries is detrimental to SC/ST members. In the case of J. Chitra versus District Collector, court has noted that the purpose of verification of caste certificates is to avoid false and bogus claims, and reopening of inquiry can be only done when certificate is either issued without proper inquiry or it is a case of fraud. In fourth important news, Supreme Court has held that repeat of OBC reservation before SC reservation is not in violation of the rotation policy. In the case of Sanjay Ramdas Patil versus Sanjay and others, the court has noted that according to the Maharashtra Act, repetition of OBC reservation in the post of mayor before SC reservation is not violative of the rotation policy. Court has held that taking into consideration the fact that the number of seats reserved for scheduled caste are 3, whereas the backward class of citizens have 7 seats, that is more than twice, it is quite probable that the post of mayor could be reserved for 2 earlier terms for backward class of citizens, whereas no reservation is provided for scheduled caste. Lastly, the Supreme Court has held that employee may challenge terms and conditions of employment if it violates statutory requirement. In the case of Somesh Thaplyal versus Vice Chancellor Garhwal University, Supreme Court has held that if an employee is aggrieved by the terms and conditions of his or her employment, which are not in consonance with the statutory requirements, he is not stopped from challenging the same. The court has said that it is not open for a person appointed in public employment to ordinarily choose the terms and conditions of which he is required to serve. The court has further also noted that it goes without saying that employer is always in a dominating position and it is open to the employer to dictate the terms of employment. With this, we have come to the end of our legal news for this week. If you like our content, please like and share this video and subscribe to our channel.